Good morning. My name is Abubakar Nadeem and my UHID number is 240599620. In this video, I will be advising Sulman on his legal rights and remedies under the Sale of Goods Act 1979 in relation to the table, chairs, and sofa he ordered from Amjad Furniture Store. I will discuss the relevant statutory provisions, apply them to the facts, and refer to sporting case law. First of all, the contract and context of this case is Sulman, who owns Haveli House Restaurant, entered into a business to business contract with Amjad Furniture Store. The contract involved purchase of 25 extra large marble tables in grey, 100 velvet dining chairs sold as X display, and one leather sofa set. This contract is governed by the Sale of Goods Act 1979 because it is a commercial sale of goods. The issue one was the incorrect tables under Section 13 of Sales of Good Act 1979. Goods sold by description must correspond with that description. The law is strict. Goods must match exactly what was ordered. Case law sports. This in Acros versus Renison 1933, even a small deviation from the contractual description amounted to breach. Similarly, in Bale versus Taylor 1967, the buyer was entitled to reject goods that did not match the description in the advertisement. In Suleiman's case, the goods were delivered were completely different from what he ordered. 10 medium marble tables, 9 wooden tables, and 1 extra large marble table. This is a clear breach of Section 13. Under Section 15B of Sales of Good Act, a business buyer may reject goods if the breach is not so slight as to be unreasonable to reject. Here, the breach is substantial. Sulman is entitled to reject all the tables, refuse to accept the remaining undelivered tables, and demand a refund. Moving to the issue 2, the quality of chairs. Moving to the 100 velvet dining chairs under Section 14 of 2 of Sales of Good Act, goods must be of satisfactory quality considering their description, price, and other relevant circumstances. Because these were sold as X display, Sulman could expect minor wear and tear, but he is still entitled to chairs in reasonable condition given the price and description. Case law is useful here. In Rogers versus Parrish 1987, even a small defect in a new Range Rover allowed rejection because the goods were not of satisfactory quality, although his case involved a consumer. Courts often rely on the same principles for business buyers. Similarly, in Bernstein versus Pamson Motors 1987, defects discovered shortly after purchase entitled the buyer to reject the goods within a reasonable time. Sulman inspected one box and found chairs with grease marks and scuffs. These appear to exceed the minor wear and tear described. Under Section 14.2, this is likely a breach of satisfactory quality. Sulman may therefore reject the chairs or alternately keep them and claim damages. The issue 3, the third issue, sofa fitness for purpose. The sofa raises a different issue. Before purchasing, Sulman specifically asked whether the leather material would irritate people with skin conditions. This is a clear communication of a specific purpose, which triggers Section 14.3 of the Sales of Good Act. Goods must be fit for the buyer's stated purpose where that purpose is known to the seller. The case of Grant versus Australian Knitting Mills 1936 demonstrate this principle. The underwear that caused dermatitis was not fit for purpose. Similarly, in Ashtington Piggery versus Christopher Hill 1972, the House of Lords held that if the buyer makes a particular purpose known, the goods must be suitable for that purpose. Saman, the sales person, reassured Sulman that the sofa was high quality and that there would be no issues. This was a statement of fact, not opinion. However, the sofa caused Sulman's daughter to develop a rash. This strongly suggests the sofa was not fit for the communicated purpose, and therefore Section 14.3 has been breached. Sulman is entitled to reject the sofa and claim damages, potentially including the compensation for the harm caused, depending on the evidence of causation. So there was also a potential misrepresentation. There may also be an argument for misrepresentation. Statements such as super popular and worth every penny are likely sales puff and not legally actionable. However, the statement that the chairs were in good condition apart from minor wear and tear could be a misrepresentation of fact if untrue. More importantly, the assurance that the sofa would cause no issues is likely an actionable misrepresentation if it was false. Cases such as Bissett versus Wilkinson, mere opinion is not misrepresentation, and ASO Petroleum versus Modern, expert opinions can amount to statements of fact, and Addington versus Fitzmaurice, misleading statements can be misrepresentation. These show that Salman's assurances may give Salman additional remedies, including the right to rescind the contract. The rejection and remedies that Salman contracted the store the very next day. Under Section 35 of Sales of Good Act, a buyer must reject goods within a reasonable time. Given that Salman acted immediately upon discovering the issues, his rejection is valid. His remedies are first of all, the reject the table's breach of description, Section 13. Second, the reject the chairs, breach of satisfactory quality and for purpose. Reject the sofa, breach of fitness for purpose, claim damages for losses caused by the breaches, and refuse payment. The seller is wrong to say Salman must accept the goods. Under the Sale of Goods Act, he is fully within his rights to reject all the goods. So, therefore, it is concluded the Amjad Furniture Store has breached multiple sections of Sales of Goods Act 1979. Salman is entitled to reject the incorrect tables, the defective chairs, and that the sofa there was not fit for the purpose. He may refuse to pay, demand a full refund, and claim damages. The store claim that is too late. The store claims that it is too late, cancel incorrectly. Salman should write to the store immediately confirming his rejection of the goods and request an appropriate remedy. The ultimate decision in this matter rests with the judge. Thank you for listening.